bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Yeah, they need the headphones. That's what I thought. All right. This is in case number, well, first of all, what is your name?
Alejandro Díaz López.
Alejandro Diaz Lopez.
All right, this is in case number 2022 MM57AA. This is a charge of battery, domestic violence. And at this time, I will appoint the public defender's office to represent you. At this time, I have reviewed the charge and affidavit, and I do find probable cause. And at this time, I don't believe there's any, are there any witnesses out there? And did you already, there's not, it's already been checked? Okay. And at this time, is there anything further from the state or the defense?
Nothing from the state, Your Honor.
Just reasonable bond conditions, Your Honor.
At this time, I'm going to require you to not return to the scene of where this occurred. You must maintain a separate residence. You're not to have any contact with the victim, and you're not to possess any weapons or firearms. Now, before you is a no contact order that states that you can't have the no contact. And did you understand that form?
Sí.
Yes.
Okay. At this time, I will set bond in the amount, see, there's an out-of-county warrant for battery. I don't know if that's been, is there a hold on them yet? I'm sorry?
Just pick up from Dade County only.
Okay. At this time, I'm going to set bond in the amount of $1,500 and with those conditions of your release. But you do need to understand if you violate any of the court's order, the bond will be revoked. Okay? And I've appointed the public defender's office to represent you. Thank you. Now, you want everything back? Okay, that's why I didn't know. No, y'all not print. I'm like, what do they want? You want everything. All right. Your name, please?
Adnel Alexander Rivera.
Abner Alexander Rivera.
At this time, you're here in case number 2022 MM629. The charge is violation of pretrial release conditions. Here's that you were just out on pretrial release, or bond in a pretrial release on January 17th. Oh, okay. And there is a revocation to be signed at this time by the court. And at this time, does the state wish to be heard on any other matter regarding this? Are you requesting a no bond? Are you requesting?
No, Your Honor, the defendant is entitled to a bond on the new offense, the violation. However, on the out-on bond, I have no objection to revoking PTR and then just setting bond.
Right, he's entitled to the bond on the new charge, but not on the violation of the pretrial release. And there's no objection to the court setting a reasonable bond in that case with conditions, and that's based upon the facts and the history.
Yes, Your Honor.
All right, at this time, I'm going to make this abundantly clear. And if you violate the conditions, this bond will be revoked. Both bonds will be revoked, and the bonds will be set at 0. Do you understand? Oh, I can take them. I'll sign them.
Yes.
Okay. And you've signed the no contact order, and do you understand that?
Yes.
At this time, on the new charge, I will set your bond at $2,000. You're to have no contact with the victim, not to possess any weapons or firearms. You must maintain a separate residence. On the charge that you were giving pretrial release on, I'm going to revoke that pretrial release. I'm going to set that bond in the amount of $2,000 also. And I'm also going to require you once again to have no contact with the victim. You must maintain a separate residence. You are not to return to the scene of any offenses where these occurred, and you're not to possess any weapons or firearms. Okay? Sir, do you understand the court's order?
Yes.
And while, don't say anything about the facts of the case, you don't say anything about the facts, I note that you said contact was due to missing her. You understand, sir, you cannot have contact with this individual, period. You understand?
Yes.
All right, and the public defender is appointed on each of the cases.
Your Honor, are those the only two cases for the interpreter?
I believe, is that correct? Yes. Is there any this afternoon? We call back this afternoon. I think this morning, that's what they're saying is it.
Thank you, Your Honor. Have a great day.
Thank you.
Stay warm, everyone, and dry.
Yes, no.
Thank you.
Uh-huh.
You're welcome. Bye.
Is that it? Okay, so they've got a separate order for that. All right. Now we're on the regular docket. Okay.
Except for Michael.
Are we doing the move up, the regular, Rena?
I think, are you here on a separate matter? I think you're here on a, have you talked with the state?
No, Your Honor, I am not.
Yeah, you, let them know. I mean, yeah, because I'm fairness to them, they.
Yeah, thank you, Your Honor.
You're welcome. All right. Thank you.
This afternoon?
All right. Your name, please?
Kayla Oliver Pratt.
I don't have
All right. I'm sorry, what was your first name?
Kayla.
Kayla. Okay. This time, ma'am, you're here on a charge in case number 2022 CF dash 1074 AO. The charge is aggravated assault, domestic violence. And at this time, I will appoint the public defender's office to represent you. I do find probable cause, and I believe we have a witness here. And we're going to have you sworn in at this time, and we'll proceed from there, okay?
Yes, I do.
Please state your name for the record and spell.
Andrew Pratt.
All right.
State your name again.
Andrew Pratt.
All right. Does the state wish to inquire?
Good morning, sir. How do you know the defendant?
Yeah, this is my wife.
And has something like this happened before?
No.
Are you afraid of her?
No, I'm not afraid of her.
While this case is pending, would you like to have contact with her?
Yes, I got have contact with her.
Were drugs or alcohol involved in this incident?
No.
No further questions, Your Honor.
And one other follow-up question, Mr. Pratt, sir. You stated that you wish to have contact. Do you all reside together?
What'd you
You
say?
live together?
Yeah, we live together.
Okay, and I thought you did, but I just needed to make sure. Do you wish that she be allowed to reside with you?
Yes,
Stay in the
yes.
same residence while the case is pending also?
Yes, this is my understanding. This good. Everything good.
Just wanted to make sure,
Yeah.
because sometimes the court will order no contact, but, or can have contact, but not sure if everybody still wants to reside together. Does the defense wish to be heard?
No questions, Your Honor.
Okay. At this time, does the state have any position then on the bond and the bond amount?
Your Honor, it appears that Ms. Pratt does qualify for PTR. I know defense will ask for that, and I have no objections. Standard conditions, no hostile contact,
Weapons
no
or
fire, yes.
firearms? Exactly. Okay. Is that what the defense is requesting also?
Yes, Your Honor.
All right. She qualifies apparently for pretrial release without objection from the state. I will order a pretrial release. At this time, you're to have no violent or hostile contact with the victim, and you're not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
Okay. All right. The public defender's office is appointed. Thank you.
Oh.
All right. Your name, please?
Lonzia Phillips.
Mr. Phillips, sir, you're here on a charge as follows, and there are 3 counts of, there's count 1, aggravated battery on a pregnant person, count 2, grand theft of the 3rd degree, and count 3, false imprisonment. Probable cause has previously been found. Bond has previously been set in the amount of $5,000 under count 1, $1,000 under count 2, and $10,000 under count 3. You're not to have any contact with the victims. You must maintain a separate residence, and you're not to possess any weapons or firearms, okay? I've appointed the public defender's officer to represent you on the matter. You do qualify, and so those will be the conditions. I believe you've got a federal probation, and is that hold been satisfied, or
No, ma'am, it's still open.
it's still open, so they're still processing that then?
Yes, yes, Your Honor.
Okay, they're probably gonna have that federal probation hold, but you do have a bond on these cases that was previously set, public defender's office, and you signed the no contact order, and you understand that, sir?
Yes, ma'am.
Okay, sir, thank you. Your name, please? Mr. Wilson, sir, you're here on a charge, sir, as follows. It's a charge of aggravated assault with a deadly weapon and battery, domestic violence. I've reviewed the charge and affidavit. This is in case number 2022 CF 1088AO. I'll appoint the public defender's office to represent you, sir. At this time, you're to have no contact with the victim. Do you understand that, sir?
Yes, ma'am.
Okay, sir. And I'm going to have you sign that here in open court. And is that your signature, sir, that you just signed on the no contact? And did you understand that all those conditions that are on that no contact order?
Yes, ma'am.
Okay, sir. I'm going to require you to not return to the scene of where this occurred. You're not to possess any weapons or firearms. And I believe you're on state probation. Is that correct? I mean, you don't need to answer, but corrections. He's on state probation.
Yes, ma'am.
And are they
I-6
processing that?
I-6 sex offender.
Okay, but are they processing the warrant, I presume?
Yes.
Okay, so he'll probably be on a hold under that. At this time, is there anything further from the state or the defense as far as the bond?
Nothing from the state.
Just reasonable bond conditions, Your Honor.
This time, sir, I'm going to set bond in the amount of $5,000 under count 1 and $500 under count 2, with those conditions the same, though, under each count. So if one of the counts are not picked up, sir, it does count, you know, it's under the conditions of the case. All right? Thank you, sir.
Your Honor, we have Andrews, Patrick as behavior.
Okay, so we will reset that for tomorrow.
We would just waive the appearance if we're appointed.
Okay. At this time, the Public Defender's Office is appointed, and you will apprise your client then of the conditions of the release also.
That's right, Your Honor, and we'll waive his appearance for
Okay,
today.
but I just need to make sure they understand the conditions, what I'm going to be imposing.
Yes, they'll be informed, Your Honor.
Okay, thank you. At this time, is there anything further from the state on that? I don't think there's any witnesses here.
Nothing from the state.
Okay. Let me look. Okay. At this time, I'll set bond in the amount of $750, no contact with the victim, maintain a separate residence, and no weapons or firearms, and not to return to the scene of the offense. Okay? And you'll let your client know those.
Yes, of course, Your Honor, of course. It makes it easier on the weekend attorneys, too.
I just want to, as long as as long as they know the conditions, I don't want to post the bond and then all of a sudden go, well, I never knew any of that. That's my, yeah. All right, your name, please?
Ashton Cantras.
Mr. Cantras, sir, you're here on a charge of battery domestic violence. This is in case number 2022 MM618AO. I have reviewed the charge and affidavit. I do find probable cause. I don't think there's any witnesses here on the matter. Is there anything further from the state or the defense?
Nothing from the state, Your Honor.
I know y'all aren't familiar with me. Usually how I do the domestic is I go through the case and if you all have something that y'all have always stood up and have got my attention, but since I'm here once blue moon, I'll just ask individually of each. All right, I'll appoint I don't think you qualify. Sir, you don't qualify for the public defender. Let me ask you, are you going to hire your own attorney?
I don't qualify for public defender?
No, it doesn't look like, how much are you working right now?
Yes, ma'am.
Okay, and how much do you make,
About $750 a week.
Yeah, that doesn't qualify.
Wow.
Yeah, that doesn't qualify. It doesn't mean at a later time, the court cannot reassess, your financial at the time, if something changes. But at this time, you do not qualify for the public defender. So I'm going to order some conditions of your release, and I need to make sure you understand them, okay? You're to have no contact with the victim in the matter. Do you understand that?
Yes, ma'am.
And you understand that's directly, indirectly, you can absolutely have no contact. I'm going to require you to maintain a separate residence. Do you understand that also?
Yes, ma'am.
I'm also going to require you not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
At this time, sir, I'm going to set your bond in the amount of $750 with those as the conditions of your release, okay?
All right.
And what I'm going to do is if you're not able to, are they doing determination of counsels? Do they do those anymore? Okay. But if he can't bond out, do they reset these anymore? No. Okay. I assume you're going to be able to bond out. If you're not able to bond out, write the court, they don't, what if they don't bond out, if they don't qualify? I mean, they haven't been addressing it?
I'm sorry?
What happens, we used to do a determination of counsel,
Okay.
like if they didn't qualify for the public defender and we didn't know if the person did or didn't bond out, we don't want them just sitting in, I mean, they may end up sitting in jail, but at least have representation, so they're saying they don't do determination of counsels. Do you all have a list or something that comes up on?
Your Honor, we can resolve this one of two ways. He actually does qualify for pretrial release, and the state would have no objection if you wanted to release him with the same conditions. Or you can sometimes temporarily appoint the public defender's office, which would give the defendant time to get their own attorney.
For some reason, I didn't think they liked the temporary, but I don't mind, I mean, if that's.
I think under the current COVID order.
I'm sorry?
I think under the current COVID order, you can temporarily.
Okay, thank
appoint
you.
us.
See, I wouldn't have thought that. And they qualify for pretrial release without the victim being here then? That used to be the other thing too. They wouldn't do that without the victim testifying. So do they do that now?
Yes, Your Honor, we just actually interview them, then we verify their community ties, and that's how we dig.
Okay,
we get
so
some.
no, not the victim, okay,
And then it's usually coupled if the victim's not present with a no contact order.
right, right.
So are you going to temporarily appoint us?
I will temporarily appoint, I will order, pretrial release in without objection from the state and also noted by the state to go ahead and go forward that. But the conditions, you need to understand, sir, if you violate any of the conditions, the pretrial release will be revoked and the bond can be set at 0. Do you understand that? Okay. And once again, no contact, maintain a separate residence, do not possess any weapons or firearms. And do you understand that?
Yes, ma'am.
Do you need to go back there to pick up any personal belongings?
No.
No. Okay, because if you did, I need to make a separate order. All right, and I've appointed the public defender's office temporarily to appoint you, represent you. Thank you. By the time I learn all this, I'll. I'll be back, and then you'll go, no, that's not enough.
We'll remind you in 6 months.
There you go. Hopefully, it's been a couple of years. All right, your name, please?
Valerie Jackson?
At this time, you are here on the following charge. You said Ms. Jackson?
Yes, ma'am.
This is in case number MM2256AA. The charge is battery. And I've reviewed the charge and affidavit. I do find probable cause. And I will appoint the public defender's office to represent you. Is the defendant out on bond?
Yes.
You don't need.
I don't believe so.
You don't need to help them. She's out on I'm showing she's out on bond for aggravated battery with a deadly weapon. Is that true, everybody? Is that what, do we have a case number?
Probation?
Yeah, she's on state probation.
She's on probation.
She's on probation, okay. I don't know why I thought she was out on a bond. Is she out on any bond also?
I do not see that, Your Honor.
Okay. All right, I'm going to talk to you about you're to have no contact with the victim in this matter. Do you understand that?
Yes.
You understand that you are to maintain a separate residence. Do you understand that?
Yes.
You also understand you're not to possess any weapons or firearms.
Yes, ma'am.
And you also understand that you are not to return to the scene of where this occurred. Do you understand that?
Yes.
Now, do you need to go back to pick up any belongings?
Yes.
Okay. What we're going to do is put in the order that you may return one time with law enforcement to pick up those belongings. When you do that, you call them in advance. They arrange when and where to meet you. Do not just drive up there and call and say, the judge said I can get my items, my personal belongings. You must arrange it in advance. So I just don't want any confusion on that. Do you understand?
Yes, ma'am.
Okay. And I guess you were released, and you don't need to answer, you don't need to say anything. It says she was released from jail and returned home on 1/27. Was that the probation case then? I've got, yes. Says the victim and Valerie had been in a relationship on 1/27. Valerie was released from jail and returned home. So I just want to make sure it's not a new charge. Is it the probation charge then? Does anybody know by chance? Nope.
No, Your Honor.
Does correction, do you all? Well, they're not showing she's out on a bond, so if it's a violation of probation, that may be amended and violated again. I don't know, I'm just reading the charge and affidavit, so I cannot tell what that charge was or was not. So at this time, I'm going to set bond in the amount of $2,000 with those as the conditions of your release, okay? I know you have a case set. I haven't had a chance to look at it. Have you had a chance to talk with the state?
Yeah, Your Honor, no, I understand. So it's for the afternoon, so I appreciate if you can, but I understand
Okay. And the charge is aggravated assault with a firearm? Yes, Your Honor. Your name, please?
Oliver Jenkins.
At this time, Mr. Jenkins, sir, you're here on a charge of battery, domestic violence, and this is in case number 2022 MM623AO. At this time, I've reviewed the charge and affidavit. I do find probable cause. I don't think there's any witnesses here. And at this time, is there anything further from the state
Nothing from the state.
or from the defense?
Just reasonable bond conditions, Your Honor.
At this time, I'm going to require you, and I need to make sure you understand, I've appointed the public defender's office. You're to have no contact with the victim in the matter. Do you understand that?
Yes,
And you understand that's directly or indirectly through a friend? It is absolutely no contact.
yes, ma'am.
Okay. We're going to have you sign that no contact order here in court at this time.
Hmm?
Okay. And is that your signature?
Yes, ma'am.
All right. You're also, you must maintain a separate residence. You are not to return to the scene of where this occurred, and you're also not to possess any weapons or firearms.
Oh,
Now-
I ain't got no guns, nothing like that.
I'm sorry?
I have no guns.
Okay, but it's now a court order. You understand? It's now a court order. You cannot, okay?
Oh.
And do you need to go back to pick up any personal
No,
belongings
no,
there?
that's my house. Nobody stayed up there but me.
Okay, well, right now, you can't go back there, okay? You're not allowed to go back there until the court has another hearing or the court can determine that the victim is not
Don't stay with
residing
me.
there.
Hold on, stay at my house.
You don't stay at the
I
house?
say, hold on, stay at my house.
Oh, she does not.
No, yes, ma'am. I locked
Well-
my house up.
Your Honor, can defense be heard?
Yes,
If you order a one-time return with law enforcement,
She's
and
not
then she's
there.
not there, law enforcement sees that she's not there, he can be able to stay, just,
Okay.
I guess, order separate residences, I guess would be the,
I'll order the separate residence at this time, and you may return one time with law enforcement. So if she's there, you understand, you can't live there. Do you understand that?
But at my house.
It does, sir, this is a court order. It doesn't matter at this time. Your attorney can always request additional hearing on the matter, but at this time, the court's going to order that you maintain a separate residence. So if she is there, you cannot live
I'm
there.
not at my house.
I need to make sure your client is.
Not to my house, ma'am.
Your Honor.
Okay.
Thank you, Your Honor.
You're welcome. I'm setting bond and I'll allow you to return one time with law enforcement to pick up your personal belongings when you do that. Don't just go there, don't drive up there. You have to call them in advance to arrange when and where for them to meet you to go do that, okay?
My car's in my truck there.
I'll take you.
Sir, I've explained it as well as I can explain it. If you have a question, I'll let you speak with your attorney and I can follow up. But those are the conditions of your release. And if you violate them, the court can revoke the bond and set the bond at zero. So I just want to make sure you fully understand that, okay?
Yes.
At this time, sir, I'm going to set bond in the amount of $1,000 with those as the conditions, okay?
Well, I can't get out of my own country. Okay, I can't get the warrant.
Thank you for explaining.
No problem, Your Honor.
I understand and I know what they're saying, but I need to make sure they understand.
I think sometimes it's when
I
it
know.
sounds like they can't go back home, it
I know.
start to get nervous.
Okay, ma'am, your name, please?
Alexis Janae McLeod.
At this time, Ms. McLeod, you are here on a charge of battery. This is in case number 2022 MM 613AO. Ms. McLeod, I need your full attention because my job today is to make sure you understand the court's order, and I need to make sure you do that, okay? I will appoint the public defender's office to represent you, so you have an attorney now representing you, okay? That's step one. At this time, you want to raise your right hand to get sworn in?
Right hand, baby.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
Please state your name for the record.
Ernest Lee Thompson.
Aaliyah Grace Gray Thompson.
Okay. And does the state wish to inquire of him?
Yes, Your Honor.
Thank you.
Good morning, sir.
Good morning.
How do you know the defendant?
It's my daughter's mother.
And has something like this happened before?
Yes,
When was the last time?
about 2 months ago.
Okay. Did you call the police at that time?
No, she did.
Okay. Were drugs or alcohol involved in this incident?
No.
Would you like to, can you adjust the microphone?
It was just finances, that's all.
Okay.
Right now, I'm in between jobs, and we just don't, the finances was just not there.
I understand.
Yes, ma'am.
Are you afraid of her?
No, ma'am.
While this case is pending, would you like to have contact with her?
Most definitely. I can't give her a bath.
Do you live together?
Sometimes we do. She have her own residence, and I have my own. But before that, we lived together for 6 years.
Okay. And so while the case is pending, would it be okay if the judge ordered that you have no hostile contact and therefore you could be at each other's residence?
Yes.
Okay. I have no further questions, Your Honor.
Do you have any, do you wish to inquire?
No questions from the defense, Your Honor.
So, sir, it's my understanding, based upon your testimony,
Yes, ma'am.
that you wish to have contact, if you all choose to have contact, that would be allowable, that would be okay.
Yes, ma'am, because we have a shared custody, nothing through the courts, but just through ourselves, and it's real hard.
Okay.
Yes, ma'am.
And you feel safe doing so with
Yes,
her?
ma'am. Like I explained to the state prosecutor, we're just having financial problems, and sometimes people have to let off a little steam, you know. And
If you've got y'all have that adorable child that you all really should be thinking long-term about, and these type
that's
of
the reason I'm.
and what she's witnessing and those type of things too. Okay, you
Well,
don't need to say anything
I
else.
try to talk to her and let her know that sometimes grown people have misunderstandings, but that doesn't mean I don't love her mother. I love her mother.
Okay, that's fine, but,
Okay,
all right, thank you, sir.
I'm good. Yes, ma'am.
All right, at this time, I'm going to appoint the public defender's office to represent you. I am going to require, though, that you both maintain a separate residence, so you cannot live together. Do you understand that, ma'am?
Yes, ma'am.
I will allow there to be contact, but it cannot be any hostile or violent contact. Do you understand that?
Yes, ma'am.
And I'll also require you not to possess any weapons or firearms. Do you understand that?
Yes, ma'am. Until this is resolved?
Correct.
Okay.
Correct. Cannot have any weapons or firearms. You understand that?
Yes, ma'am.
At this time, the public defender's office is appointed, and I'll set bond in the amount of $1,000 with those as the conditions of your release.
Excuse me, miss.
Excuse me, Your Honor.
Let the attorney talk to his client.
Hold on, wait a minute. gotta go get the money to get
Excuse me, Your Honor. When they arrested me Thursday, unexpectedly, I had got a job Tuesday, and my manager wanted me to start Thursday, but he didn't contact me. So, but I did remember him telling me he wanted me to start Saturday. He wanted me to open and close on Kirkman at Wendy's. I got the job, but I didn't start yet. He doesn't know I'm here. And I also went to orientation, the FCC. It's the beginning of the year, and a bond reduction, please, because I have goals, and I've already signed up for school. I'm trying to get my high school diploma and become a dental assistant. I can't become a CNA with the battery on my record. It's the beginning of the year. I have goals that I really need to succeed with for my daughter. I waited 5
Your
years to
last
get back in
conviction
school.
Was for a battery back in July of
Yes, ma'am.
2019. And you've got a prior petty theft, and you've got some juvenile history involving similar offenses.
Yes, ma'am. Back in the battery, I was staying at the Coalition for the Homeless.
Okay. You may not want to
was-
say, I just don't want you, and the reason I just don't want you to say anything to be used against you is what I'm.
I don't have nothing to
determining.
hide.
The court notes that she is above average, and the court is looking at the type of offenses. Does the state have a position on lowering the bond to $750 or $500?
Generally, Your Honor, for the misdemeanors, it is $500, so I don't have any objection to lowering the bond.
And the court knows that there's some general amounts, but the court does take into account history too, absolutely, as I believe I need to. But in noting this, and I will set the bond at $500 then. All right, thank you.
Thank you, Your Honor.
You're welcome, thank you, but you all just kind of think long-term too. Think
I'm
you both
55, I've
don't
been-
say anything.
Trying to get there.
She's gonna let you out. All right, the next case we have is, you want to come on up, please?
Thank you.
Thank you for your consideration, Your Honor.
You're welcome. Your name?
Alicia Mendiola?
Ma'am, you're here on a charge as follows. This was a charge of battery, and this was a warrant, I believe. No, I'm sorry, there's a warrant. Don't say anything, but there's a warrant out of Washington State. That's correct. At this time, I've reviewed the charge and affidavit. I do find probable cause. You do qualify for the public defender. I'm going to appoint them to represent you, the public defender's office to represent you. And at this time, I'm going to set bond in the amount of $500 with the following conditions. You're to have no contact with the victim. Do you understand that?
Yes, sir.
Do you understand you're to have no contact?
Yes, ma'am.
I just need to, I need to make, I
Yes.
understand there's a lot going on in the
Yes,
courtroom.
yes, ma'am. I'm sorry.
But that's okay. We just need to, my job is to make sure that, that everybody understands any order that the court does impose.
Yes, ma'am.
At this time, you signed the no contact order and
Yes,
you
ma'am.
understand that. All right. You must maintain a separate residence. You're not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
Okay, and the bond will be set at $500 and you have the public defender's office appointed on the case. Thank you.
Thank you.
Your name, please?
Adam Rana.
Rana, sir, you're here on a charge, sir, of battery, domestic violence. I'm showing that you don't qualify for the public defender. So let me just ask you a couple of questions. Are you working at this time?
Yes, ma'am.
And how much do you make? We've got it listed as take home.
It's an average. We do sales, so right now I'm about $3,000 a month.
Okay. All right, yeah, you don't qualify, but I will temporarily appoint the public defender's office to represent you then at this time.
Thank you.
And,
Your Honor, the victim is also the co-defendant who should be the next person.
want to
Sometimes the
explain
court will hear them together just so they can both say whether or not they want to have
that.
contact.
We'll do that. You want to bring?
He's mental health.
Okay, then never mind.
Yeah, because I know that you all used to do that too. All right, at this time, let's go ahead and start back to where I was on this. You're not having any contact with the victim, do you understand that? I know that they're also charged, but I just need to make sure you understand that.
I have my own residence, yes, ma'am.
Okay. And you're not returned to the scene of where this occurred, do you understand that?
Yes, ma'am.
And also, you're not to possess any weapons or firearms, do you
Yes, ma'am.
understand that? Yeah, this is Adam. And at this time, I'll set bond at $500 with those as the conditions of the release, okay?
Thank you so much.
You're welcome, sir. To the public defender's office, would you mind just inquiring? I'm always very cautious about people saying things on the record that I've asked something and they respond. Is the house the other individual's house?
It's my parents' home,
Okay,
but I have my own house,
okay,
so I have no problem not going back there.
okay. For the next individual, for your,
The location of the alleged incident is usually the language I would use to
yeah.
tiptoe around that.
Okay, thank you very much, and those are the conditions.
Thank you so much.
You're welcome. All right, so we have the next individual that it's going to have to be reset because there's a PTR issue that probably needs to be addressed tomorrow. Aren't they out on pretrial release?
Ma'am, the case actually closed. It's just still showing active.
Okay, so it's closed out?
Yes, ma'am.
Okay, then I don't mind. I just was, I didn't want to take an action on that one without the other. I don't have any paperwork filled out, qualify. What is everybody's position? Do you want to reset? I know we don't,
This is for Michael Rana.
yeah. They say the pretrial release is closed out due
Yes, it
to
is, Your
that.
Honor. It was
Okay,
closed.
So if appointed, we would waive.
okay.
Would he qualify for PTR in this case?
No, due to open mental health cases he has going on, all you can do is a mental health PTR.
Are y'all doing mental health or bond?
I would argue for a reasonable bond, Your Honor.
I'm going to roll this till tomorrow, everybody. I just think sometimes you got to get a little hands-on of what's going on. I know we try to do everything we can to not do that, but there's just some cases I think that might need. And maybe by then they might get additional information that might solve some of those other,
That's
or
fine.
answer some of those questions. All right,
fine, Your Honor.
your name, please?
Mikhail Treasure?
I'm sorry, what was your name?
Mikhail Treasure.
All right. Mr. Treasurer, sir, you're here on a charge as follows. It is in case number 2022 MM620AO. The charge is battery domestic violence. I've reviewed the affidavit and I do find probable cause. I will appoint the public defender's office to represent you. And if you would raise your right hand to get sworn in, please.
You swear to tell the truth, whole truth, nothing but the truth, so help you God?
Can you answer a little louder?
Yes.
Thank you.
Please state your name for the record.
Brianna Buckridge.
Pull the mic down so you can hear it.
Brianna Buckridge.
And does the state wish to inquire?
Good morning.
Morning.
How do you know the defendant?
He's my daughter's.
He's your,
He's my.
ma'am, I can't hear you.
She probably needs to be a little bit
he's
closer to
my
that
daughter's
microphone.
father. He's my daughter's father.
Okay.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
No.
Are you afraid of him?
No.
While this case is pending, would you like to have contact with him?
Yes.
Do you live together?
Yes.
I have no further questions, Your Honor.
Is the defense?
No questions, Your Honor.
And you all stated that you do live together. If the court, do you still want the ability to live together if that's what you both choose to do?
Yes.
Okay. All right. I believe it qualifies, or let me hear from the state. The state's position on the bond?
As you were about to note, Your Honor, yes, he does qualify for PTR. I have no objection to PTR. However, based on the allegations in this, I would actually ask for no contact, as the mother was holding the baby at the time that she was struck and the baby was struck at the same time. So just based on that, I would ask for no contact, but I have no objection to PTR.
Is DCF involved?
He didn't put his hands on me.
But is the Department of Children and Families involved at this time?
Huh?
Is anybody else investigating the case about the baby?
Yes, Your Honor, DCF was called. As a DCF investigator at HARA ID number 415 was contacted and will be completing a report.
Your Honor, based on witness testimony, she has testified that she wants contact, they live together, they have a child in common. So I would have you take that into account and order no hostile contact along with pretrial release, as he does otherwise qualify.
I'm gonna, what I'm gonna do at this time is I'll allow the pretrial release, and you must abide by the following conditions. You're not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
Okay. I'm also gonna require you to comply with DCF. That's the Department of Children and Family Services.
One question. What does PTR mean?
It's where you don't have to post a monetary bond. There's, they should have you a form, or they usually go over that with you. Do you understand that now your attorney was beside you?
Sorry?
Do you understand that now that your attorney was standing there beside you?
Yes, ma'am.
Okay, and if you don't, just say, Judge, I'm still not sure. It's a non-monetary bond. You don't have to post a bond, but there's conditions that you have to comply with while you're out on that release. And if you violate that, the court can revoke that pretrial release and set the bond at 0, okay? All right, so I'm gonna allow you to have no violent or hostile contact, but I need to explain something real clear, because this is where, if the Department of Children and Family Services and they've been contacted about the baby, if they say you both cannot have contact, do you understand you must comply with their order?
Yes, ma'am.
Okay, so the order is going to say no violent or hostile contact, comply with DCF, no weapons or firearms, and I'll order pretrial release, okay? All right. And you'll be released today under this case. And do you understand that also?
Yeah.
Okay. Thank you. And I think to the state that kind of satisfies both of those if they, sometimes understand why I don't, because there's I just, 2 court orders, one saying contact, one no contact, but I feel pretty confident in this one that it'll probably track each other. All right, your name, please?
Morris Breckenridge.
Mr. Breckenridge, sir, you're here on an out-of-county warrant, sir, and at this time, that court has issued a warrant, set your bond at 0, and they will be notified to have you picked up and returned to that county, okay?
Your Honor, can you just say what county it is, please? Which county?
Seminole.
Thank you.
You're welcome.
And Your Honor, may our office be appointed in these out-of-county warrants just to prevent anybody from falling through the cracks before transport?
Do you all do that now?
Usually, yes.
Do they? Oh, okay. I'll appoint.
Because sometimes they'll be waiting for transport and
Right.
no one will be there to argue for them.
So is it a temporary appointment? Okay,
Thank you, Judge.
you're welcome. Ma'am, you can come on up. Your name, please?
Taylor McDaniel.
Ms. McDaniel, you're here on an out-of-county warrant also. This is from, let's say Lafayette, but, yeah, Lafayette County. And at this time, the court there, let's see what it says. Okay. They've checked with the county. I'm going to appoint the public defender's office to temporarily appoint you. Teletype, they faxed over the warrant. Says a cash bond of 500, but has both charges. They now are following up to see is the cash bond on which charge. Was that done to corrections?
What I see, there's, 2 charges with 1 bond because, it's a blanket bond.
Okay. So are they checking on that then?
No, I just believe, it's just 500 for both
Right.
charges.
That's what it looks like. They didn't do per count, they just did it with the case. Is that what you're showing? 500?
Yes, Your Honor.
Okay. The bond will remain the same at the $500 cash bond. That's what they've got listed.
She's saying when she talks to the bondsman that they're saying it's higher than that? Is it, maybe they're calculating it wrong? Maybe they're doing 500 for each count?
Yeah, that's what they're saying, it's 500 for each.
They might be saying it's none under one because they don't have a bond amount. That's why I think corrections was checking again. Corrections, I mean, what? Warrant is active, failure to appear, charges, second count, no valid, cash bond 500, we will our place hold. I'm showing it's at 500 cash bond. They just, they didn't do a second count is what, I mean, they didn't put an amount under counts two. They did it under the case. So I'm showing it as 500. Is that what corrections is showing also? Just so I'm,
Yes, Your Honor.
okay. So you will also think it is a $500 cash bond?
Yes, Your Honor.
Okay. All right. Thank you.
Thank you so much.
Does the state show that too? Do you?
I don't have any information.
You don't
to
have that, okay. What it showed was count one, it was a failure to appear, was set $500 cash bond. The second count was the same type of charge, no valid.
Oh.
But it just didn't have a bond amount, it didn't have anything. So I don't, because we used to do a one bond under the whole case. And so I don't know if that was the intent or, but it did say $500 cash bond. All right, your name,
You
please?
want to see a copy of it?
Oh, no.
Okay.
Lauren Zamowski.
All right. You're here on a charge, this is a out-of-county warrant also, and this county is from, why am I not seeing where the county, let me look. Where is it? Oh, Broward County. And that court there has set $1,000 under each count, okay? If they don't extradite you or pick you up, the case will be reset for the court to review. And I will temporarily appoint the public defender's office to represent you. Thank you. They're pretty easy, right? They're like the old ways, right? Your name, please?
Leroy Betor.
Sir, at this time, you're here on a violation of probation, sir. I will appoint the public defender's office to represent you on the matter. You do qualify. The bond is set at none. The case will remain in the division in which it was originally assigned, and that's in Division 17. And you'll be set for a VOP arraignment or status probably in the next couple of weeks, okay?
All right, thank you.
Thanks, sir. Sir, your name, please?
EJ Ellis.
Okay. You're here on it's a violation of probation, and the court, I will appoint the public defender's office to represent you, okay? You've got a public defender appointed to represent you, And I'm showing the bond is set at none. Is this an on-view? So this is an on-view violation of probation.
Yes.
Okay. And what will happen is the bond will be set at none, and what will happen is the judge that's assigned to the case will probably get a violation of probation warrant to sign, and if they change the bond, then that would be the bond. But at this time, the bond is set at none, and you've got the PD appointed, okay? Thank you.
Just be advised, he does have an immigration detainer.
Okay. And you do have an immigration status hold also. Right, okay, I'm just advising you that. All right, thank you.
Okay, thank you, ma'am.
You're welcome, the PD's appointed. Your name, please?
Chris Hinton.
At this time, sir, Mr. Hinton, sir, you're here on a violation of probation, sir. That warrant has been signed and been set at none. I will appoint the Public Defender's Office to represent you. Are you hiring your own attorney, or?
I have an attorney, ma'am.
You do have an attorney? Okay, and who is that attorney?
Daryl Smith.
Okay, and the case will be set, we'll have that, you have your own attorney. Do you show the notice in there yet? It may not be filed yet, but you'll be set, I think, aren't these cases set within like 2 weeks or 10 days now for an arraignment? So if you haven't been able to retain them at the time, the court can look at the PD. He's in there. Okay, thank you. Sir, your name, please?
Timothy Hoffman.
Mr. Hoffman, sir, you're here on a charge of a violation of probation, sir. That court has also issued a warrant and set bond at none. And are you hiring your own attorney, or do you wish to have an attorney appointed?
I hired an attorney.
You're hiring your own? Okay. Have you done, don't say anything you said, but have you retained an attorney yet, or you just know you are going to?
I'm in the middle of figuring it out.
Okay.
Asking for a bond to be set, but I do.
Do you want the public defender appointed at this time, and they can always withdraw in case you're able to get that attorney? Okay, so I'll appoint the public defender's office to represent you at this time. That way you've got an attorney, you know, you're not, especially on these no bonds. And then that way, if your attorney does get hired, they can file a notice of appearance, okay? He's in on no bond, he's not working. Mr. Russ, what does he have? All kinds of violations. You're welcome, sir. All right, Mr. Russ, sir, is that correct? Sir, your name, please?
Zachary Russ.
All right, Mr. Russ, sir, you're here, case number CF 2020, 9259, 6940, and then also 3351. On each of these cases, you do qualify for the public defender. I'll appoint the public defender's office to represent you, sir. And bond has been set at none on each of these matters. And you'll have the public defender appointed. Okay? Thank you. You're wearing this thing in here. I'll be getting another one. I don't know what is in it. All right, I have not had a chance to review this, so let me look. Thank you. Are we supposed to be scanning? Oh, okay. All right, you may proceed.
Thank you, Your Honor. Samantha Angelostro on behalf of Mr. Brian Foltz.
Okay, Mr. Foltz is here on 3 counts of aggravated assault with a firearm. This is in case number 2022 CF 1062AO. All
Your
right,
Honor, if I may be heard as to bond.
yes.
I understand that Mr. Foltz does not qualify for the pretrial release program. I would just ask the court to consider a reasonable bond on this case. He's not a flight risk. He doesn't have any criminal history. He has 1 arrest from 2018, which the charges on that case were not pursued. He lives in Parkland, Florida, with his wife and 2 children. They are minor children, ages 11 and 9. He has a stable residence as he's lived there for 2 years. He is a veteran. He was honorably discharged from the Army, and he is also an attorney with a stable occupation. He works out of South Florida. So we would be requesting a reasonable bond on this case.
And have you had a chance to speak with the state?
I have, Your Honor. I believe the state has no objection to Your Honor setting a bond.
No objection, Your Honor. I was looking at the bond schedule for a third-degree felony, which aggravated assault with a firearm is a third-degree felony. The range is between $1,000 and $2,500.
I just have a couple of questions.
Yes, Your
And I
Honor.
know you want to probably speak with your client, you know.
Yes, Your Honor.
I see how this began.
Correct.
I saw how it began. What if anything, is there any counseling? Is there anything that he's starting? I mean, there were some issues that were of some concern, and that's what precipitated the entire incident even beginning.
Yes, Your Honor.
So that's the court's question is when the bond is set and the amount it is set, what is the next step that is occurring to ensure the court of the safety of everyone?
Yes, Your Honor. Mr. Foltz does have a medical provider that he goes to. He takes medication for his conditions. He does suffer from post-traumatic stress disorder due to having 2 tours in Iraq. But he does take medication, and he is wanting to continue taking that medication and get back on track.
All right, at this time, I've reviewed the affidavit, and I do find probable cause. And is everything, you feel, I shouldn't say you feel good today. You're in the middle, you're in the Orange County Jail, but are you doing okay today? Yes, Your Honor. Okay. And what is your date of birth?
August 13th, 1984.
Okay. And you're an attorney also?
Yes, Your Honor.
All right. At this time, I'm going to require you to possess absolutely no weapons or firearms. Do you understand that?
Absolutely understand, Your Honor.
What does he want on turning those in? We used to have them turn in
My firearm was taken, Your Honor.
24 hours, 48, 24 hours. I'm going to require you not to possess any, and they took the firearm from you last night, correct?
Correct, Your Honor.
Okay. If you have any other firearms or weapons, you must turn those in within 24 hours of your release. Do you understand that?
I do, Your Honor.
Okay. I'm also going to require you to comply by any prescribed medication that is prescribed, all right? I will require you, I'll set bond in the amount, does the state object to a $2,500 bond under count 1, count 2, and count 3 at $1,000 each?
No objection, Your Honor.
I'm going to set bond at $2,500 under count 1, $1,000 under count 2, and $1,000 under count 3. But the conditions all remain the same. I think you understand that, but I just need to make sure under the same under this entire case, whether one charge is picked up or all 3 are. Okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Okay. Anything further, counsel?
Just if we could clarify, Your Honor, may he surrender the weapons if he does have any at his residence to his local police department? Yes. Thank you.
Okay.
That's all, Your Honor.
All right, thank you.
Appreciate it.
Your Honor, I know it's not likely, but can we also order no contact with the victims?
Sure. Absolutely. No contact with the victims in the matter.
I don't even know who they are, Your Honor.
I understand, but I thank you for the state for reminding me to do that. All right, everybody, thank you.
Thank you, Your Honor. I appreciate the court being accommodating.
Oh, you're welcome. Thanks for waiting. I just didn't have a chance. I saw you sitting there, and I do try to take y'all, you know, I mean, I try to make it as fair as I can for everyone, but I just didn't have the ability to look at it till just right now.
Right, I definitely appreciate it.
All right, thank you.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
I just need the warrant. Does anybody? Yeah, that's what I need. Yep, that's what I need. Mine won't let me open up anything. It says I have to open a new Adobe, and so I couldn't, so I may have to get you later. All right, your name, please?
Tyrone Hines.
All right, and at this time, you may proceed, counsel.
Okay.
Yes, Your Honor, this is we would like to submit an admission to violation of probation. The terms admit to a technical, return to probation, 30 days in OCJ. I believe he has 32 days credit time served and $182.50 court costs. This is in case 2020 MM 8564 AOR.
So he's reinstating to probation, right?
That's correct.
And for a period of how long?
That I don't know.
Says he was placed on it on April the 28th, and then was sent, the warrant was signed on 8/18, so we've already used up, what, April, May, might as well call it close to 60 days. I don't know what he had for time served, so I've got to take that off. I mean, we can reinstate him. I've got 180 days. I can just start it back at 180 days, which is probably, I mean, he didn't do anything, so
Just allow me a moment, Your Honor.
no problem. I just don't see any advantage to, in other words, you violate, you get less time, so that doesn't make,
Yeah, the original issue was he was set up for a hearing on 125,
okay.
where he was going to enter this, but there was a transport order that I guess he wasn't brought over. So we're doing it here. I do not know.
What courtroom who are we doing it on behalf? Judge Jewett's division? Okay, because he was out here, probably, right.
Yes, but the client wasn't there. There was a transport order in place, though, but.
And this is in agreement with the state also?
Your Honor, I apologize. I don't see any notes, and so I'm just confirming, since there were questions, I'm just confirming what the offer is from the state.
He was put on it originally for 180 days, and so we've got 180 days because it's an M1, so to me, you shouldn't get, I mean, my gut is you shouldn't be rewarded for never doing anything to put, so at least it would be the 180 days with those conditions. You know, 32 days, credit for 32 days, restart a new period of probation, 180 days with all the original conditions, which I don't even know what they were, everybody, so I need to know what they were. Anger management, does he have to do that, or, I mean?
Yes.
Sorry, I ask a lot of questions, as you
Okay.
probably can tell now.
Oh, it's fine.
It looks as though it's 6 months of supervised probation, complete anger management program, no contact with the victim or family, no return to this scene, and court costs and fine. So it appears as though the only thing he really had to do while on probation was complete the anger management class.
Correct. But I don't think he said that was the agreed upon offer. I mean, what, did you say it was reinstate all original conditions?
Well, this was admission to technical, it says RT probation, I don't know what that means.
What did it
usually
say?
revoke and
Terminate, right. Revoke and terminate,
Just
new
read it
period of
then.
probation, right.
30 days OCJ and then $182.50 COS, cost of
Supervision?
supervision, maybe?
Right.
Forgive my knowledge.
That's okay. He's 182, cost of supervision. What we need to do is, because I kind of want to move the docket along, we're probably going to start, I mean, I know, I want you all to be real clear, you know what, from your respective ASA and Assistant Public Defender also. But normally it is reinstate with original conditions if they haven't been completed. But if that wasn't the offer, I don't want to add something. So are you,
May we recall this case later? I have a chance to speak with state for a second.
yeah, that's fine. Okay,
We can continue the docket.
yeah. And I would tell, let me just tell you what I would, was it adjudicated originally?
Yes, he was previously.
Okay. What I'm inclined to do, everyone, just so you'll know,
That's usually constituted.
is he's previously been adjudicated, revoke and terminate probation. 32 days in the Orange County Jail with credit for 32 days time served. Placed on a new period of probation for 180 days, which sounds like, and then special conditions will be to complete the anger management class, still no contact with the victim, no return, still the original conditions. And the cost of supervision, $182.50, and do they do payment plans anymore? Just give $100 a year to pay. Okay, but we'll call it back after you get a moment to just, maybe you can shoot a message to your
Yes.
yeah.
They drop this on.
If they say they don't want the anger management because he served jail, I'm fine with that too, but I just usually, all right, your name, is this? Okay, we're gonna do everything.
He's Korean, but let's see if you don't understand.
Okay. All right. Can you tell me your name?
명환윤.
Is the public defender gonna get appointed? Do you understand okay, great. All right. You're here on a charge of trespass after warning. Do you want an attorney to help you?
I need to understand, yes.
Yes, okay. I'll appoint the public defender's office to represent you, okay? So you now have an attorney and you're shaking your head yes.
ma'am.
You can't go back here. Do you understand? You can't go back. You're shaking your head to that. And the bond is set at $1,000. I didn't know if there was.
Your Honor, as to his lack of criminal history and the lack of severity on the charge, would you consider an ROR or a low monetary bond on this?
I'll consider a different bond. I probably won't consider ROR just because.
I don't mind either way, Your Honor. He has no history, and the offer was a withhold.
Okay, so you don't mind an ROR then?
I
Okay,
don't.
All right. I'll ROR you. Now, do you understand what I'm going to release you on your own recognizance, but you can't go back there. Do you understand that?
Yes, ma'am.
Okay.
Not go back there.
The blue martini.
Okay.
Okay. All right. Public defender is appointed. Don't go back there.
Call us.
Okay. When do I need to call?
All the time. Make sure you have court dates. Talk to an attorney and ask for, hold on.
Here's that BOP case. Did I keep that? I'm sorry, the plea. The plea. Okay, all I have is this. Gotcha.
You talk to your attorney.
I just did.
Okay? All right.
Okay, Your Honor. Lee Terrence, he refused.
Terrence Lee
Terrence Lee.
refused, okay. Well, he's out on bond.
From One Delta?
He's got 2 cases.
Oh, hold on, Your Honor.
I can't, I don't do them very well.
Oh, he's here. I apologize.
Okay. So it's drug paraphernalia. All right, Mr. Lee?
Yes, ma'am.
All right, Mr. Lee, sir, you're here on 2 cases. And the first one is possession of drug paraphernalia, and the second one is a disorderly conduct.
Your Honor?
We have an offer.
With regard to the drug paraphernalia, 22 MM 625, the state announces a no information. With regard to the disorderly conduct, which is a city ordinance, the general offer is a withhold of adjudication and credit time served.
And court costs.
And court costs, yes.
Moment, Your Honor.
Okay. And he's not on probation. That's the one question I always ask.
He's not.
All right.
Your Honor, I've spoken with Mr. Lee about the state's offer as well as went over the plea form with him. I believe he wishes to resolve today.
Okay. Mr. Lee, sir, then do you want to, how are you wanting to plead? Guilty, not guilty, or no contest?
No contest.
And is that your signature, sir? That's going to be on the plea form right there. I'll need you to sign that, okay? As best as you can.
Yes, ma'am.
Okay? Do you want all these? Do you want these? And Mr. Lee, do you understand that you're giving up the rights on this plea form? There won't be a trial, there won't be witnesses called. We'll be resolving the case today. Do you understand that?
Yes, ma'am.
Okay. Are you on probation for any charge?
No, ma'am.
Okay. And at this time then, the state is no billing. They're dropping the paraphernalia charge. And so this is the charge only of the one count of disorderly. So I will, at this time, withhold adjudication. I'll sentence you to the 2 days you served in jail. Nope, 1 day.
1 day.
Came in after midnight. So it's 1 day in the Orange County Jail with credit for time served. Now, there's court costs. I can't waive them, but I'll give you a year to go ahead and pay those off, okay?
Yes, ma'am.
All right, sir. You have the right to appeal the sentence of the court. You must do so in writing within 30 days. If you can't afford an attorney, one will be appointed to represent you. And at this time, the state announced a no.
No bill, no information.
No bill, no information.
I'm sorry, Judge. Oh, the Adam Bond case?
I'm not going to take any action because you pled to the new charges.
Okay.
So no action will be taken, and you'll be released on that other case also.
May I inquire, are we appointed in the out on bond case 22 MM 559?
I'm showing, it says public defender, it says Peter Lee.
Okay. Just wanted to make sure. Okay. Thank you. I do have the PD in the violation of the probation case that can call in if we had a.
Okay. Is the state ready? Do you have, I mean, what did your PD say then?
Well, she says she can call in, but I don't have a number or the link.
She's going to call in here?
The link for the jail, yeah.
If she goes on
I don't want to.
Ninja 9,
Sorry, I.
go to like Bain's website, all of them have a link to how to get into the jail. But Bain, I believe, really does have.
Is this, you said this is the public defendant on this case? On the.
On the one we will recall later, the.
Right. Okay.
Christina Medina, I believe, is the name of the APD.
Okay, can't she just tell you what it is and I mean, whatever.
I just feel like, because it's her case, she'd be more prepared to argue the conditions.
I'm not going to argue anything. It's either agreed upon or not.
Not argue, but present the conditions better than I could, I guess.
What is the state? Y'all, usually when these in jail, I don't know, but I'll give you a heads up. Usually the in jail are either agreed upon, they're agreed upon. We don't get into too much of the.
I think state and I have agreed on the terms,
Okay.
the admission if.
Your Honor.
Uh-huh. It's okay, everybody. I just.
If we could just leave this to the end of the docket, I think by the end of the docket, there should be enough clarification for me to be able to move forward one way or another.
Okay.
Thank you.
I mean, in fairness, everybody, you know, it's their case that they've agreed upon, I presume, you know, or thought it was agreed upon, so we'll just recall it, no worries. All right, so, and she's welcome to join us, it's not that, I just, usually everybody kind of knows what they have on that. All right, in which case?
Your Honor, Mr. Battle, his behavior.
Okay. Mr. Battle was a failure to appear. His bond is set at none. And does he qualify for the public defender? Did he fill out anything? I can go ahead and appoint. It was a failure to appear. This is Timrell Battle. Do you want to go ahead and waive the appearance?
Yes, Your Honor.
Okay. The public defender's office appearance waived. That bond was already set at 0 by that judge. Okay?
It may be a VOP, so you could go ahead and enter an admission.
And you already had the PD.
Confused everybody enough.
Okay. You just want to show me the little thing so I know.
It's a failure to appear.
I think it was on a VOP hearing, but it's all right.
You can come on up. Your name, please?
Kenneth James Purvis. Good morning, Your Honor.
Good morning, Mr.
afternoon.
Purvis. Mr. Purvis, sir, you're here on a charge of an open container?
Yes, ma'am.
All right. And at this time, sir, I've reviewed the affidavit. I do find probable cause, and I'm not sure if there was an offer and what that offer was.
Yes, Your Honor, the offer is a withhold of adjudication and credit time served along with court costs.
All right.
And I did have a chance to speak with Mr. Purvis, as well as conveyed the offer and went over the plea form. Believe he wishes to resolve today.
All right. Mr.
Yes,
Purvis,
ma'am. Yes,
sir?
sir.
Do you wish to enter a plea of guilty, not guilty, or no contest?
We're going under guilty.
Guilty or no contest?
Oh, no contest.
Okay, it means you neither admit nor deny, but you want to resolve the case today, but for purposes of sentencing, the sentence would be the same, okay?
Okay.
Is that your signature, sir, that is on the plea form? I'm going to have you go ahead and sign that in open court.
Yes, ma'am.
Did you understand, sir, the rights you're giving up by pleading here today?
Yes, ma'am.
And are you on probation for any charge?
No, ma'am.
And you understand, sir, are you under the influence of any alcohol, drugs, or medication that could affect your thinking today?
No, ma'am.
Or are you thinking clear and understand everything?
Yes, ma'am.
All right, sir, and do you still wish to continue with your plea of no contest?
Yes, ma'am.
I'll accept your plea. I find sufficient facts to do so. I'll withhold adjudication, sentence you to 2 days in jail with the credit for the 2 days. There's court cost, and I'll give you 1 year to pay those, okay?
Okay, yes, ma'am. And I talked to my case manager yesterday, and I told her I was going to work on getting my license this year and tighten up some fines I got. Thank you
Okay.
very much, Your Honor.
Yeah, and if you do that, you know, you can always go into the clerk's office and see about them trying to assist you in under some payment schedule to help with those two, okay?
Yes, ma'am, I will. I will.
All right, sir, thank you, and you'll be released under this case today.
Okay. Thank you very much, Your Honor.
You're welcome.
Very much, sir. And I'm going to work on it. No BS. Thank you.
All right, sounds great. Your name, please?
Richard Ortiz. Good morning, Your Honor.
Good morning, sir. Mr. Ortiz, sir, you're here, sir. This was a warrant that was issued. A probable cause has already been found. I'm going to appoint the public defender's office to represent you on the case. So you've got an attorney, sir. The bond will remain the same under each count. The burglary of a conveyance is $2,500. Grand theft is $1,000. The credit card theft is $1,000. Unlawful possession of a stolen credit card will remain at $1,000, and fraudulent use of a credit card remains at $1,000. Now, sir, you're not to have any contact with the alleged victim, okay?
Yes, Your Honor.
And the public defender is appointed on the case, and those will be the conditions of your release.
All right. Thank you.
Oh, well, that's because they're so out of order, right? That's okay, it's here. It's these things, you know, I just, Sir, Sir, your name, please?
My name is Rashard Siraj, ma'am.
Mr. Siraj, sir, you're here on a charge, sir, as follows. This was a warrant that was issued. It's attempted first-degree murder with a firearm. Probable cause has already been found, sir. I will appoint the public defender's office to represent you at this time. Okay? And at this time, is there anything further from the state or the defense?
I have no argument at this time.
I didn't think so. I just wanted to make sure. Sir, this time the bond is set at none, and you do have the public defender's office appointed, okay?
Yes, ma'am.
Thank you, sir.
Thank you. Have a great day.
He is entitled to an Arthur hearing with his attorney downtown.
I know.
Set bond.
I just wanted to, since I have it, I'll know now.
I'm sorry?
I'll know now on these, and I know that's how it used to be. I just wanted to make sure I wasn't presuming something.
Of course, Your Honor. May I have a moment to confer?
Sure.
That's where they'll set bond.
Your name, please?
Holly McNulty.
At this time, you're here on a charge of battery, and count 2 is criminal mischief. Are you going to hire your own attorney, or do you wish to have one appointed?
I don't think this, can we, what was the last name? McNulty?
Oh,
It's only here for a petty theft, I think.
oh, well, okay, I've got something. No, that's not Jennifer. Jennifer Burr?
Your Honor, she was bonded.
Oh, okay. No wonder you looked like, what was I? Okay. No wonder everybody jumped up and it looked that way. All right, Ms. McNulty, you are here on a charge of petty theft, prior theft conviction. You do qualify for the public defender. I will appoint them to represent you. The bond is set at $500. All right?
Okay, thank you.
If you do bond out, I do need to add one thing. If you do bond out, you are not to return to the scene of where this occurred.
I'm sorry.
When you post your bond, you're not to go back to the 7-Eleven. Do you understand that? Okay, thank you. Your name?
Stephen Dwayne Usher, ma'am.
Mr. Usher, you're here on a charge as follows. It's a charge of possession of cannabis less than 20 grams. The public defender's office is appointed.
Your Honor, at this time, the state announces a no information.
At this time, the state has announced a no information, so I'll take no action on that on case. And, yeah, she dropped it. She dropped the new charge. I wonder if he had to notify the jail of his new address. I wonder since he got picked up, if he had to notify them that he had been picked up on the failure to register. Yeah. Hmm. Your name, please?
Nicholas Wachek.
I'm sorry, what was your last name?
Wachek?
All right. Sir, you're here on a charge as follows. It's a charge of trespass on warning, on property after warning. I'm showing that you qualify for the public defender. And at this time, I don't know if he can plea. He's got a warrant out of Georgia.
We aren't interested in pleading today, Your Honor.
Okay. All right. At this time, sir, the bond will remain the same at $500, and you're not to return to the scene of where this occurred. Okay?
If I may humbly ask to resolve this issue?
Well, I think your attorney is, I think he's kind of concerned because you've got a warrant out of Georgia for a violation of probation, And if you plead to this, it can be used in that probation case, potentially. It's an older POP, but I think that your attorney wants to talk to you about that first. I know you're still. And you don't hear it clicking on like. Your name?
Kara Howard.
Ms. Howard, you're here on the following charges. This was a failure to appear, 2 counts for, I believe it was arraignments. The court set count 1 at $250 for selling tobacco cigarettes to a minor, and count 2, alcohol beverage to a person under the age of 21. They've ROR'd that.
There was an offer to resolve, Your Honor. I did have half a second to speak with Ms. Howard in the back, if I have a moment to confer to
Sure.
confirm her thoughts on that.
Okay. I'll need a factual basis to the state on it. If she resolves, all I have is the warrant.
Yes, Your Honor.
Thank you. And unfortunately, I'm not logged in over here. Okay, and how does your client wish to proceed?
I believe she wishes to resolve today. I spoke with her briefly about the rights to be waived, as well as any citizenship or probation issues. I believe she still wishes to resolve.
Okay. And you understand if you're not a U.S. citizen, this charge and plea could be used in a deportation.
Yes, ma'am. I'm from
I just wanted you to make sure. I think
Yes,
that's
no, I'm
why.
from Rochester, New York. I'm sorry.
Okay, that's okay. It's just, I think he was wanting to just ensure, we'd rather everything be on the record, and if you have any questions, they're answered, all right?
Yes, ma'am.
So at this time, as to the charge, count 1, selling tobacco, cigarettes to a minor, and count 2, alcohol beverage, serving or selling to under 21. One was tobacco, one was alcohol, I presume. How does she wish to proceed?
No contest.
Okay. We have a plea form.
I have one right in front of her, Your Honor.
Okay, and what is the offer?
It is an adjudication of guilt and credit time served. And then I don't know if the mic picked it up, but she did plead no contest.
I'm sorry.
And she's signing the form now.
Thank you. I don't know how much time served.
The 2 days.
2 days. And the state, could I please have just a short factual basis?
Yes, Your Honor. Sorry, I moved away from that screen.
While you're doing that, I'll just review the plea form.
If we were appointed, I signed the plea form, just
Okay.
in case.
Yes, you were.
Not, it might save her. Okay.
Is this your signature on the plea form?
Yes, ma'am.
Did you read and understand the rights on the plea form?
Yes, ma'am.
And do you have any questions regarding these rights that you're giving up by doing so?
No, ma'am.
Are you on probation for any charge?
No, ma'am.
And are you under the influence of any alcohol, drugs, or medication that could affect your thinking today?
No, ma'am.
And do you need any further time to speak with your attorney regarding this matter?
No, ma'am.
Okay. At this time, then, if I could have a factual basis.
Yes, Your Honor. An underage witness who is 18 years old purchased beer and cigarettes from the defendant, who was a cashier at 7-Eleven. Defendant did not ask the age or for ID at the time of the purchase. This happened in Orange County.
Okay. Court does find sufficient facts to take the plea. I'll adjudicate you guilty, sentence you to 2 days in jail with credit for 2 days' time served. You'll be released under this case today. And I won't take any actions on the 2 out-of-bond cases because you've resolved the case today. And at this time, the court cost, I'll give you 1 year to pay them, okay?
Thank you.
You have the right to appeal the sentence of the court. You must do so in writing within 30 days. If you could not afford an attorney, one will be appointed to represent you. Sir, your name, please?
J. Antonio Comisberger.
Mr. Colesman-Berger, sir, you're here. This was an arrest warrant for a charge of petty theft, having a prior theft conviction. That court set your bond at $1,000, and you're not to return to the scene of where it occurred, and no contact with any employee of GameStop.
Yes, ma'am.
The public defender's office is appointed, sir, and the bond will remain the same. All right?
Is there, so I could bond out on this charge?
Yes, sir? This
Or-
has- yes, sir.
They said previously my bond was revoked.
The case in front of me, it might be on another case. This was an add-on. So maybe on another case, they've revoked it. But on this case, this was a warrant that was issued. And you do have a bond on this one, okay?
Is there a way that my bond that was revoked, I could get it on, like a bond on it?
You'll have to have brought that up at a different time and where, in front of that court to address that, okay? But I didn't revoke your bond on this one. It's $1,000. You're welcome, sir. Your name, please? Mr. Campbell, can you tell me your name?
I can't hear. I can't hear. I need,
Hold on, Your Honor.
Okay,
sorry.
that's all right. No, we. Can you hear me now?
Yeah, I can hear you
Okay,
now.
I just don't want to shout, so just let me know if I'm too loud, okay? Can you tell me your name, please? Can you tell me your name? Can you tell me your name?
No, I still can't.
You can't. I just don't want to. No?
Yeah, now.
Now you can. Okay. Can you tell me your name?
James Campbell?
Mr. Campbell, sir, you're here on a charge of disorderly conduct.
Yes, ma'am.
And are you trying to resolve the case today, sir?
Yes, yes, ma'am.
Okay. Are you on any kind of probation?
No, ma'am.
All right. Let me hear what the offer is.
The usual offer for our city county ordinances, if I'm correct, is withholding credit time served.
That is correct, Your Honor.
And I did have a chance to speak with Mr. Campbell in the back. I also gave him a plea form to review, went over the rights as well as any issues with probation and citizenship I believe he wishes to resolve today.
Thank you very much. All right, Mr. Campbell, sir, how do you wish to enter your plea, sir? Guilty, not guilty, or no contest?
No contest.
No contest.
Okay, I'm gonna let you go ahead and sign it, and then we'll talk, okay? All right, sir, and is that your signature that you signed on the plea form?
Yes, yes, it is.
And did you understand the rights you're giving up by pleading here today?
Yes, I do.
And are you on probation for any charge?
No, ma'am.
All right, sir. And are you under the influence of any alcohol or drugs or any kind of medication that could affect your thinking today?
No, ma'am.
So you're thinking clear today and you understand?
Yes, I am.
All right, sir. At this time, I'll accept your plea. I find sufficient facts to do so. I'll withhold adjudication. I'll sentence you to, you served 2 days in jail, so credit for those 2 days' time served. Okay?
Okay.
And now there are court costs. I can't waive those. Can't just
All right.
magically make them disappear. So if you, I'm going to give you a year to pay it, okay?
Okay.
All right, sir. Do you have any other questions? You'll be released today.
No, sir. I mean, no, ma'am.
All right. All right. Okay, thank you.
Oh, take care. Oh, you're good.
Your name, please?
Yes, it's George Holman, Your Honor.
Mr. Holman, sir, you're here on a charge of disorderly conduct. At this time, I find probable cause. And is there an offer to resolve the case? The Public Defender's Office, you qualify.
To withhold of adjudication and credit time served.
I did have a chance, Your Honor, to speak with Mr. Homan about the state's offer as well as gave him a plea form to review. We went over the rights to be waived. and any citizenship and probationary issues I believe he wishes to resolve today.
Okay. All right, Mr. Holman, sir, it's my understanding you wish to plead, is it guilty, not guilty, or no contest?
Yes, yes. No contest,
All right, and
Your Honor.
is this your signature that you just signed on the plea form?
Yes, it is.
And did you understand the rights you're giving up by pleading here?
Yes, I do, Your Honor.
Okay, and are you on probation for any charge?
No.
Because you're sometimes
No,
the only
I'm
one
not.
that would know that. Okay.
Your Honor.
And do you understand everything that's going on here today?
Yes, I do, clearly.
Okay, sir. And
Your
do you have
Honor.
any other questions or any other questions for your attorney?
No, no, I don't,
All right,
Your
sir.
Honor.
I'll accept your plea. I'll withhold adjudication. I will sentence you to the 2 days you served in jail with the credit for those 2 days' time served. So you'll be released today. There's court cost that I'll give you 1 year to pay, okay? And if you can't pay them, just try to get down to the court, to the clerk's office and see if there's any payment schedule or any ways to convert that to a civil lien, or there may be other options.
Thank you.
You're welcome,
Thank
sir.
you, Your Honor.
Thank you. You'll be released today.
All right. Thank you very much.
Your Honor, Mr. Hall is a bond. He bonded.
He bonded, okay. Thank you. Your name, please?
Mundedrick Mitchell, ma'am.
Mr. Mitchell, sir, you're here on a charge of driving while license suspended. And it was a failure to appear. The court issued a warrant and set your bond at $100. I'm going to appoint the public defender's office to represent you, okay? And I think it's Division 80. It looks like Division 8.
Judge, he has a open case in Osceola.
He has an open case in Osceola?
Mitchum, correct?
Mitchell?
Yes. I have it on my face sheet.
You said an open case. I don't think they.
Yes.
Okay, I guess he's out on bond. But this was a failure to appear. And this failure to appear was,
Ma'am, can I talk?
I think your attorney, I don't want to stop you, but usually they don't want you to say anything until they have a chance to speak with you. See, I don't show where. This warrant looks like it was issued in January of that's 2022. Yeah, they just didn't have the paperwork for it, so we didn't have it. Does the state wish to be heard on it? This was a failure to appear on the no valid, or a driving while license suspended.
No, Your Honor, I believe what corrections is bringing to your attention is this defendant is also out on bond.
Right.
With the Osceola case, it has been filed on. I have no problem with no action, Your Honor. This is a driving with license suspended, and what he is out on bond for is a theft offense, so.
Okay, and he's appearing, and he's had a date, there's no issue. Okay, I won't take any
He's been working
action.
with our office and been appearing for court in Osceola, so.
Okay, I won't take any action on that out on bond then. Okay? You're welcome. Your name, please?
Jamal Adams.
Mr. Adams?
Yeah.
Okay, Mr. Adams, sir, you're here, sir, on a charge. This was a charge of possession of cocaine, and an arrest warrant was issued by a judge, already finding probable cause. The bond will remain at $1,000, and I have appointed the public defender. Okay?
Can I say something?
Probably don't want to say anything. Your attorney's going to probably tell you not to say anything, because they don't want it used against
A
you.
moment to confer, Your Honor.
Mhm. come on up. Your name, please.
Matthew John Armstrong.
What happened with Billy Atkins?
He's next.
Oh, I must have handed you. Did I hand the paperwork over? This is, what is your name again?
Matthew John Armstrong.
Okay, Mr. Armstrong, that's okay. We just got some things, mixed in a little bit. All right, Mr. Armstrong, you are here on the following charges, and this was an arrest warrant. A warrant was issued and already probable cause has been found. And this is battery on a law enforcement officer, fleeing and attempting to elude an officer, resisting without violence, and driving while license suspended. You qualify for the public defender, so I'm going to appoint the public defender's office to represent you, sir. You're not to have any contact with any of the victims. You're not to possess or consume any alcohol, illegal drugs, or controlled substances without a valid prescription. And you're not to drive without a valid license. That was in the original warrant, so I'm just stating what that is on the record. At this time, sir, the bonds will remain the same at $10,000 under count 1, $250 under count 2, $150 under count 3, and $100 under count 4. I'm showing he is out on a bond, but I do believe that out on bond, the new case occurred in August, and the out on bond case occurred after that.
Correct,
In other
Judge.
words,
Okay.
Correct.
Yes, Your Honor, I was wondering, can I get my bond reduced?
has to probably have a hearing on that. Does the state see that on his, one that they've got on out on bond?
Oh, it's fine, Your Honor. Yes, thank you.
Okay. It looks like it happened before.
That's right, Your Honor.
Right.
Thank you.
Your name, please?
Billy Atkins.
Mr. Atkins, sir, you're here on the following charges. First of all, you do, yes, you qualify for the public defender. At this time, I will appoint the public defender's office to represent you, sir. The charges are burglary of an unoccupied dwelling, possession of drug paraphernalia, possession of marijuana over 20 grams, trafficking in cocaine, 28 grams or less, or 28 and less than 150 kilograms, criminal mischief, and petty theft. And at this time, the public defender's office is appointed.
Your Honor, may we request that some of the charges be treated as a subsidiary to reduce the bond amount? And count 4 would be the big ticket item, if you would consider the other counts as subsidiary.
Can I have the attorney's approach? And I'm going to go off the record, then I'm going to come back on. All right, we're back here on the record, and Mr. Atkins is present. There's just some discussions regarding the subsidiary and the charge and affidavit. Court had found, or finds probable cause, but I will, as to count 1, 2, and 3, I'll reduce those bonds to $150 each. As to count 4, that will remain at $50,000. Count 5 and 6 will remain at $500 and $500. Now, I'm going to have specific conditions of this. You're to have no contact with the co-defendant. You're not to return to the scene of where this occurred, and you're not to possess any illegal drugs or any drugs without a valid prescription. Was there anything further from the state on those conditions?
No, Your Honor.
Have a moment to confer, Your Honor.
You know, we've been where. All right, thank you, sir. All right, we then, the next case, you want to come on up?
Your Honor, Castillo Cosme bonded.
Okay, thank you.
This is Mr. Cologne.
Your name, please?
Esteban Cone, ma'am.
You're here, this was a warrant that was issued for grand theft of the 3rd degree, so another judge has already found probable cause. I'll appoint the public defender's office to represent you on the matter, and the bond is set at $1,000, also with the condition that you have no contact with the victim, you not return to the scene, and you not possess any weapons or firearms, okay?
All right, am I allowed to bond out? 'Cause when I asked when this warrant was issued, they said March 21st or on the 21st or something. Like I never knew about this.
I don't have any action, I'm not taking action on your probation. This is the new charge.
All right.
This is the warrant, okay?
All right.
All right, thank you. I'm not taking any action on your probation. Your name, please?
Michael Dozier, Judge.
Mr. Dozier, sir, you're here on the following charges: trafficking in cocaine, possession of cannabis greater than 20 grams, and also a charge of resisting officer without violence. Are you hiring your own attorney, or do you wish to have one appointed?
No, ma'am, I already have attorney.
You do have an attorney? Okay. At this time, sir, probable cause was already found. You know, another judge already reviewed the warrant and found, or rather, I'm finding probable cause. And the bond is set at $50,000 under count 1 and $150 under counts 2 and 3. If you are able to post your bond, sir, you're not to have any drugs without a valid prescription.
May I speak to Mr. Dozier as a friend of the court, Your Honor, before he says anything on record?
Yes, thank you. He does not want to speak. Oh, 100, I'm sorry. Count 3 was 100. My eyes. Your eyes get dried out in here?
May I speak, please?
Mr. Dozier, sir, I'm telling you, you had your attorney here, your attorney would say, do not say a word. I mean, I'm just.
It's as to bond, Your Honor, if that's any
I'm
consolation.
satisfied with the bond amount, sir, at this time. It shows you also are on state probation. So I suspect, sir, they're going to be, I don't know, they're probably going to be filing a violation. I just don't want you to say anything to be used against you, okay? All right, sir.
Thank you very much.
Thank you.
He said thank you.
All right. Your name, please?
Brian James Dundas.
Mr. Dundas, sir, you're here on the following charges, sir. This, first of all, you do qualify for the public defender. I'm going to go ahead and appoint them, okay, to represent you. You're here on a charge, the first charge is possession of fentanyl, and count 2 is possession of drug paraphernalia. I've reviewed the charge and affidavit. I do find probable cause, sir. Bond will remain at $1,000 under count 1 and $100 under count 2. You're not to have any drugs without a valid prescription, okay? You're just not to have any drugs without a valid prescription. I believe you are also, you've got an out-of-county warrant from Broward or Brevard. If you post your bond, sir, they'll probably, you know, send you on to that county, but you've got the PD appointed, okay? Your name, please?
Rachel Francois.
Ms. Francois, you're here, this was a failure to appear, and the court that issued that warrant set bond in the amount of $2,000 under count 1 and $100 under count 2. And these are charges of possession of cocaine and possession of drug paraphernalia. The public defender, do you want an attorney on the case? Oh, previously appointed. And as to the out on bond case, is there anything further from the state?
I'm sorry, you and I can't hear you.
She's out on bond on a case. Is there any action? This looks like it might have occurred. This was a 7/13. The charge she's in front of me now on was for July the 13th of 2021 for failure to appear. She has a newer case that appears, the date of that arrest was over a year ago too, so.
I wrote the judge. I spoke to the judge. My father died. I was in the hospital.
Okay, just a minute, ma'am.
Like, I can't believe. I spoke to the judge.
Okay, ma'am, Francois, it's not gonna, let me hear the state first, okay? Does the state wish to be heard on it?
Your Honor, with regard to the out on bond, she's been referred to pretrial diversion, so at this time I would take no action because I'm sure if the state is going to do something, they will at a later date.
State is not requesting any action because you're looking at the pretrial diversion case. I don't know if you're going to get in it, but maybe they've taken into account these other charge. I don't know. But I won't take any action. You'll still be under that same status. Okay? I don't know what she's, it's not, yeah. Yeah, that'll have to go in front of that judge. But I didn't revoke the other one, so she can bond out.
Thank you, Judge.
You want to come on up? Uh-huh. Your name, please?
Louis Frederick.
Mr. Frederick, sir, you're here. This was a failure to appear, sir. The court issued a warrant and set bond at none. At this time, sir, you do qualify for the public defender, and I've appointed them to represent you. Okay? You'll be heard in front of that court again. Thank you. This is Ms.
A moment to confer, Your Honor.
Okay. Ms. Garrett, you're here on the following charges.
Yes, ma'am.
Is that your name, Ms.
Yes,
Garrett?
ma'am.
I just want to make sure I got the right case.
Ma'am, I just want to say, my girlfriend, mom. Okay, go ahead. Okay.
Nothing to say quite yet. Public Defender's Office is appointed.
Yes, ma'am.
This was a failure to appear in 2020 CF 10072AO. That court set bond at $5,000. That will remain the same. There is a new charge that probable cause has already been found on by another court also, and that were the charges of retail theft, 4 counts of neglect of a child, resisting officer without violence.
Right, this is all something that I knew of when I came to jail, ma'am, is what I'm saying to you. I knew of the 2 warrants, but I did not know of the child neglect. Ma'am, I'm 29 years old, never had my kids took from me anything.
This is a probable cause, ma'am. There's nothing, it's a probable cause has already been found by a court. So they've already reviewed. Now, I'm not suggesting this is probable cause. There's a difference between proving the case beyond a reasonable doubt and what the
Understood.
state may file, okay?
Well, what I'm saying is, ma'am, my bond is $70,000, ma'am. Like, it's nothing like, what could I, like, what could I do as far as that? Like, I got a bond in Volusia County for $40,000 for something 2 years ago, and then I got something here,
You'll have to have a
$27,000.
hearing. What will happen is your attorney can always set a hearing
Mhm.
on this other case, okay? Bond will remain the same under each of those counts.
Mhm.
You're not to return to the scene. You're to have no contact with the witnesses or the co-defendant, and you're not to have any contact with any minor child under the age of 18, okay? But the PD's appointed on all the cases on this matter, and those will be the conditions of the release under the one case as previously announced. Your name, please?
Your Honor,
Sorry.
Dedo Matute was a bond,
Okay,
and Higgins also was a bond.
okay. Thank you.
Luciano, step forward.
Your name, please?
Pablo Luciano.
Mr. Luciano, sir, you're here on the following charges, sir. This was a charge of trafficking in cocaine, less than 200 grams. There are 2 counts, an unlawful use of a 2-way communication device, count 3. You do qualify for the public defender. I will appoint the public defender's office to represent you. Probable cause has already been found under each of those counts, and the bond has been set at none under count 1 and count 2, and $2,500 under count 3, okay?
Your Honor.
So, and they've filed their notices already, yes.
You are able to change the bond amount on a warrant, and under these 2 counts, count 1 and 2, he is entitled to a bond.
Okay? If I could get somebody to print me the arrest affidavit, I mean, the probable cause, yeah. I just have the arrest.
I would also request, Your Honor, treating counts 2 and 3 as subsidiary to reduce the bond amount.
Let me look at the warrant, I haven't had a chance.
Of course.
And the next case after that, the Stephen
That was a bond. He bonded.
Marquez Fernet, okay, thank you.
Marquez Fernandez, Stephen.
And the next case is Matthews after, right? Delicia Matthews? Okay. Oh, I have that. Oh. I need the actual arrest warrant. It appears that there's 2 separate dates. I need where, like, the judge signed it. All right, we're back here on the matter with Mr. Luciano's case. Public Defender's Office has been appointed, and counsel, you are correct, he's entitled to a bond. And that is under count 1 and count 2. The court has reviewed in setting the bond, has reviewed the actual warrant, and has reviewed those in open court. At this time, the court in setting the bond also notes the defendant's history, and the court does find, I know there was the argument you had stated to treat as subsidiaries. They're two separate two different time frames, so they will not be treated as such due to that. And the court at this time will set bond in the amount of $250,000 under each count 1 and count 2, and $2,500 under count 3. You are to possess no weapons or firearms. You are not to, I'm sorry, did the state wish to be heard?
Oh, no, Your Honor.
Okay, and was there anything further from the defense? I know you had just, he was entitled, and then I said I was going to review that, and I did review that, okay?
And may I inquire, or may I ask, Your Honor, to the high amount on count 1 and 2 is due to the history?
History, the facts surrounding the case, the fleeing, the gunshots that were heard, the 2 different times, the number of times the attempt was made for the trafficking. There's a numerous, those are the reasons the court has included that, including the fleeing too and the flight risk.
May I just add a point for the record, Your Honor? Oh shoot, what's it called? The bond schedule, excuse me, usually sets these counts at 50,000 or 100,000 if it was with a weapon. I just wanted to clarify with the court that you would still raise those counts under your, it is your discretion, of course, but.
The court in reviewing the actual warrant itself does find that $250,000 is appropriate in these matters. Not only is it the weight, but it is in addition, as I stated, the gunshots, the fleeing, the number of contacts, and this was over a period of a long time that the process had been going on. So I do find that the bond is appropriate in this case as to these factors and including the history also.
Understood, Your Honor.
And so at this time, once again, you're not to have any weapons or firearms, and you're not to have any drugs without a valid prescription, and no contact with any co-defendant. Now, Mr. Luciano, sir, this doesn't prohibit you from, tomorrow your attorney can set it for a bond hearing. You understand? This is the court's determination right now for the probable cause, and the probable cause has already been found, and the court's setting a bond at this time. Okay? And I'm sure your attorney will not want you to probably say anything regarding this. Do you all have access do you all have access to the warrants?
I do, Your Honor. I don't know about the
Do you
public
get
defenders.
access to them? Yeah.
Usually do, yes.
Okay, I just wanted to make sure, because I know that sometimes, at one point they weren't, and then I think there was that you all should be able to have access, which you should, absolutely, on that. I just wanted to make sure.
Yes,
All
I
right.
can usually access them.
Yeah.
Yep.
Your name, please?
Alicia Matthews.
Ms. Matthews, you were here, let me go ahead and, on a charge as follows. It was burglary of an unoccupied dwelling, drug equipment possession, paraphernalia, marijuana possession, cocaine trafficking, and criminal mischief with property damage, and also petty theft. The Public Defender's Office, you qualify. I will appoint the Public Defender's Office to represent you on the case. And was there anything further from the defense?
Oh, yes, Your Honor. I believe this was a co-defendant in the Atkins case. We had a discussion on those charges. And in the interest of equity, I would just have you set similar bond amounts, treating counts 1, 2, and 3 as subsidiary to number 4, count 4, and then stay in the counts 5 and 6.
No objection, Your Honor.
At this time, you're not to return to the scene of where this occurred. You're not to have any contact with the co-defendant. Do you understand that? And you're not to possess any weapons or firearms?
Yes, ma'am.
Or any drugs without any illegal drugs, any drug without a valid prescription, okay? I'm going to set your bond under count 1 at 150, count 2 at 150, count 3 at 150, but count 4 will remain $50,000. Count 5 will be 500, and count 6 will remain at 500 also. You do have the public defender's office appointed on the case, okay?
Your Honor, Kelly McLuhan, she refused.
She was what?
She
Oh,
refused.
she
to come
refused?
to court.
Okay. Well, she's out on bond, I'm showing, and she has a new charge of the exact same charge, so I think it's one that needs to be reset for tomorrow. Does the state agree?
Your Honor,
Or is it the same warrant, the same charge?
I think it's the same warrant.
It is?
I think so because maybe pretrial release could confirm, but there isn't a case number for this, for the fleeing and attempting to elude and
Yeah,
the
I'm
no
gonna look
bail?
into it right now.
So she's out on bond under that one, but it looks like she was arrested on the same. I can't tell if they're. That's why I was kind of hoping she would be here.
Right, there, for the 22 CF 88, she was arrested January 3rd.
Correct.
But I don't, and when I read the affidavit, it doesn't give any new facts. So
No.
I think it's the same one.
Because it said they went to arrest her on the warrant.
Right.
And then they said she was not in the room, she was gone, and they said, no, she's really in the room, but there was no additional movement that day. I mean, do you see that?
Yes, Your Honor.
Yeah. You can ROR her under the new charge.
If it is listed as a new charge, yes, Your Honor.
Yeah, it's kind of. I mean, I don't think you want to, you're not wanting, you want to drop it right now, or
Oh,
you
no,
just?
no, Your Honor. I'm saying if we can determine that it is
The same charge
right,
as.
then yes. But there's still the,
Right, there's the
misdemeanor.
other case.
Right.
Just when we needed to see someone, huh? All right, let's look at that. And in the meantime, were you going to tell us something about somebody else, maybe?
Yes, Your Honor. Nicole Machad, she also refused court.
She bonded?
She refused.
Oh, refused? Okay, I can take care of her case. It's a probable cause has previously been found. Bond will remain at $1,500 on hers with don't possess or consume any alcohol, illegal substance, or controlled substance without a valid prescription. That was according to the original warrant that was issued. And the public defender's office will be appointed.
We'll waive the appearance today.
Okay, thank you.
No, I'm sorry, I'm looking at it.
Now, LaChana Monroe.
Okay. Is everybody okay? We keep going while we're looking that other one up? Okay. Ms. Monroe, you're here on a charge as follows. It's a charge of possession of methamphetamine. I do find probable cause. Do you want me to get you an attorney to help you? You want an attorney appointed to help you? You need a lawyer?
Probably.
I mean, it's a felony.
Yeah, because I never had a felony before.
Okay, well, That's probably even a better reason why you want a lawyer. I'll appoint the public defender's office to represent you, okay? All right, your bond is $1,000 and you're not to possess any illegal drugs, okay? All right. What's the little quick little thing y'all just mark in there now on the drugs? Okay. And the next case?
Your Honor, do you have Rupert Panigua?
I do.
He's in the hospital.
Okay.
This is Mr. Perez.
It's a failure to appear. Will reset once released from the hospital. Is that what your preference is on those or not?
Managua? Managua?
Yeah. I'm sorry, what? No, wait, I've got,
I mean, for hospital cases, I would still waive because they'd still get a bond. And
Okay.
They'd hear from us.
well, this is a no bond.
On the Manigua case?
P-A-N-I, who did you say? Yeah.
Yeah,
Yeah, I'm showing it's a zero bond.
usually sometimes warrants come in on no bonds, but you can still set a bond, especially he's entitled to the bond on these charges.
It was failure to appear.
Oh, I thought it was a warrant.
No, it was a failure to appear. But, so that's why I didn't know. He was on home confinement, it looks like. Looks like an older case, 2010, so you may not want to, you know what I mean? You may want them set, so maybe that, I don't know.
It says that it's a warrant.
I'm looking at P-A-N-I-A-G-U-A, Rupert.
May council approach to see the pages?
Sure. To see the warrant, well, that's what's attached, I mean, David. Yeah, there it is. So you may not want to waive them, because maybe the next time they might consider, yeah, it's fair to appear. Okay, no problem. Okay, gotcha, that's fine. You're welcome. All right, so at this time, Public Defender's Office is appointed, waived his appearance. So it'll be waived and bond will remain at none as was originally noted by that judge.
Thank you, Judge.
Okay, and your name?
My name is Angel Luis Perez.
Mr. Perez, sir, you're here on the following charge, sir. It's a charge of sale and delivery of cocaine. I'm showing that the Public Defender's Office, you do qualify, so I'm going to appoint them, sir. Bond will remain at, I find probable cause, bond remains at $1,500, and you're not to possess any illegal drugs, okay? Oh, 15,000. I'm sorry, y'all. I've gotten too many pieces of paperwork now mixed up.
Your Honor, would you consider a bond, what, would you consider a bond reduction
Let me look.
on the?
Yes?
Those two cases that you asked about, I believe there's two different cases because there's two different case numbers. One she's been arrested for, and the other she had, it was just a warrant for her arrest.
Right, but we think the facts are the same. Sure, yeah, you come on up, sorry.
Where's?
Right. Fleeing attempted to elude, yeah, and then, let's see. First appearance. See, that's the affidavit that issued the warrant. And these facts, it just shows they went to issue the warrant. It says, went to her house for an active warrant. This report will be forwarded, revealed. That she took her to get dressed and they. Right, for that one. Does the state know? Because I'm struggling.
Your Honor, it actually is two different cases. There's the one from January 3rd, and then when they went to go pick her up, she again fled from officers.
So then they went back this next time, and that's what this arrest came from. And that's the arrest date.
Yes, Your Honor.
Okay. Well. So that court all right. She, does the public defender want to be appointed on her or go ahead and appoint her on her? This is on Kelly McClellan.
You're
wanna go
asking
ahead
if
and
we
be
want to be
appointed?
appointed? That's fine, Your Honor.
We'll go ahead and appoint. And it is 2 separate fleeing attempting to elude. So they went to go arrest her on the one warrant where she had a $1,500 bond and a $1,000 bond after she had previously fled. So PC's been previously found. On the case number 2000, his case out of the way, that's my problem. CF 2022-1096AO, the bond will remain the same, because those were part of the arrest warrant. Am I correct, State? They were going to arrest her on those. Their warrant was issued. This is really confusing.
I just opened that. Sorry, I'll look again.
She's got an out on bond, and
Yeah, affidavit for arrest warrant.
they were bond at $1,500 and $1,000. So those bonds will remain the same. I don't think there were any other conditions. On the out on bond, though, which she was out on bond on the same charge and had bonded out on 1/10, January the 10th, I'm going to revoke that bond. I'm setting bond in the amount of 0 under that, and that's 2022 CF 88AO. Public Defender's Office is appointed. And then she also had a third case. Do you show that too? All right. 2022 MM622AO. I do find probable cause and bond will remain the same under each at $500. But, okay,
We'll waive her appearance for all
okay.
hearings today.
Thank you. And y'all are appointed, and she has a bond on everything except the old charge she was out on bond on.
Any conditions, Your Honor?
Under the third case, do not possess any drug without a valid prescription. And under the fleeing and attempting to elude and the no valid, I think it was, don't drive without a valid license. Okay. All right. That was just, thank you, and thank you Corrections for also helping. And your name? Your name?
My name is, talking.
Okay.
You were halfway through, Mr.
We were,
Perez.
Mr. Perez and Wednesday. All right, Mr. Perez, you, as I stated, you were here on sale and delivery of cocaine. The bond was set at $15,000, which I originally said $1,500 because I read it wrong. And I do find probable cause. Public Defender's Office was appointed. They had asked if I would consider lowering the bond, is where we left it off at. And I was starting to look at what the prior history was and some additional information. And that's as far as I got, okay? 2005. And to the state.
Your Honor, I would ask that the bond be left where it is.
And that's based upon, sorry.
It's essentially the schedule for the offense.
Okay,
Would the court consider a $7,500 bond?
I'm looking at his priors. His priors are quite lengthy, but I'm looking, I also, in considering priors, look at the time frame too of when they occur.
Of course, Your Honor.
I don't know when the last charge was. I show a last conviction was for trespass in 2017. I do show a lot of unknowns, one DOC, and that looks like it was back in 2005, and he has some failure to appears. It just says some failure to appears. At this time, let me look at one other matter. Does correction show anything more about the failure to appears when they were, or is that like?
Yeah, we just put for the last failure to appear.
Yes, if you have
Oh.
that,
Yeah, for 2017.
2017. Okay. I'll set bond in the amount of 8,500, okay?
Thank you.
But once again, sir, those conditions, you understand. Okay, thank you.
Thank you.
And to the state, did you wish to be heard any further on it?
No, Your Honor.
All right, your name, please? Oh, I say that before I see you standing there.
Your Honor, we have Quinones Rosario Osvaldo as medical.
Okay. At this time, public defender want to go ahead and be appointed on the matter?
Yes, Your Honor, we'll waive the appearance as well.
All right, bond will remain the same at 1,500 in count 2, 1,000 under count 3. Do not possess any illegal drugs without a valid prescription, or no drugs without a valid prescription. Okay. Your name, please?
George Sanchez.
Mr. Sanchez, sir, you're here, this was a failure to appear, sir, so a warrant was already issued for you, sir. To set bond at none under the case. I'll appoint the public defender's office. Do you want them appointed to represent you?
Oh, yes,
Get an
please.
attorney? Okay. I'll appoint them to represent you, and they'll have to try to get the case heard in front of the court that issued the warrant, okay?
Is there any way I could get a bond?
You'll have to have that bond hearing heard in front of the court, the division where the case is assigned, because that judge issued the warrant, okay?
How long does that process usually take?
I don't know, every judge is different, but your attorney has the information to tell you who to call, I bet, on that sheet of paper he's showing you. All right?
Okay, thank you.
You're welcome. Your name, please?
Kristen Schneider.
All right, Ms. Schneider, ma'am, you're here. This was 2 probable cause orders. In other words, another judge has already reviewed the cases and found probable cause. I will appoint the public defender's office to represent you. And at this time, as to the first case, it is a charge of grand theft greater than $750. The bond is set at $500. Conditions of that bond are that you have no contact with the victim, also that you not return to the scene of where this occurred. As to the second case, probable cause was already found on that also. It's a charge of petty theft, having 2 prior convictions. That bond was set at $2,500 with the following conditions. Once again, you're not to return to the scene of where this occurred. You're not to possess, consume any alcohol, illegal drugs, or controlled substance without a valid prescription. You're not to possess any weapons or firearms. And they also included not to drive without a valid license. I'm not sure it was a... I'm not, do you have a license?
No, I got suspended. I actually just got out of prison, so,
Okay.
well, still in prison till Tuesday, but.
Okay, maybe something, I don't know, I've got to, that's what that judge ordered, that, sign that warrant, okay?
Okay.
All right, thank you, but you have the PD appointed on the cases.
Would we be able to reduce that $2,500 bond for a petty theft?
It's not charged as a petty theft, it's charged as 2 prior convictions, so it's a felony case at this time.
All right, yes, ma'am.
Thank you.
Thank you.
Your Honor, Mr. Spencer refused also.
Mr. Spencer reviews, okay. PD appointed,
If appointed, we'll waive the appearance, Your Honor.
all right. And state probation also. I'm showing he's on probation. This time, I'll appoint the public defender's office to represent. Probable cause is found. Possession of ammunition by a convicted felon, 2 counts, and then possession of a firearm by a convicted felon. Got the bond set at none.
I believe he is entitled to bond on those charges, Your Honor.
I'm sorry.
I believe he is entitled to bond on those charges,
He is.
if you're inclined to set one.
State?
They are second-degree felonies, Your Honor. The range is generally $2,500 to $5,000.
What's he on probation for?
I think it's aggravated assault, wasn't it?
Aggravated assault with
Okay.
weapon, no intent to kill.
Have they filed it yet? I'm sure they will. I mean, it's, yeah. All right, at this time.
Yes, they had addressed his violation on the 20th.
I'm sorry, I'm sorry.
His on violation of probation.
Uh-huh.
Yeah, they already addressed it on the 20th or the 13th.
Okay.
He got another hearing for his a future hearing for his VOP.
Okay, he's already got it. Is the bond none on those?
Yeah. Yes.
Okay. At this time, I'll set bond in the amount of $7,500 under count 1, $2,000 under count 3, and $2,000 under count 4. I'm sorry, $7,500, $2,000, and $2,000. I'm adding him another count. He doesn't need that. And not to possess any weapon or firearm. Okay? Who is this?
To Leroy Amos.
Mr. Amos, sir, you're here on a charge as follows. It's a resisting officer without violence, battery on a law enforcement officer, possession of a controlled substance, and possession of drug paraphernalia. The court has issued a warrant and set the bond at 0 at this time.
That's because I was at ISIS. I've been at ISIS in April.
Have you? Okay.
In April last year.
Well, they'll want to look at that, and your attorney's going to need to also get that information for the judge. And I've appointed an attorney to represent you, okay?
Okay, ma'am.
All right, sir. But let them know that so they can get that information reviewed.
Yes, Your Honor, because he does have a immigration hold on him right now.
There is another one. Oh. All right, sir, your name, please?
Yes, ma'am. Jeffrey Williams.
Mr. Williams, sir, you're here on a charge, sir, of, it was a warrant that was issued, and the court that issued it, it's possession of cocaine, possession of drug paraphernalia, and resisting officer without violence, sir.
Yes, ma'am.
Do you want the public defender appointed to help you?
Yes, ma'am, if I may. Ma'am, the day I paid my bond and got out, they told me I would have to do the urinalysis. I informed them that I didn't have any transportation back over here. Would it be all right for me to do a urinalysis here? They said that was not the way they normally do it. So I called my lawyer and asked them to call them and try to explain to them my situation, that I was homeless, that it was going to take me the better part of the next day to get these bus passes to get back over here. For some reason, he said he called, but he couldn't get through to them. I came the next day, just like I told him I would. I stopped by his office. He told me to go straight over. The man said he had already sent the stuff back to the court. So I went back to my lawyer's office, explained to him what had happened. They wouldn't let me do the urinalysis. I told him. He said he would take care of it.
Well, unfortunately.
And yes, sir, ma'am. I don't know what happened. And now I'm here.
Well, Mr. Williams, that's where I've got you, the public defender's office is appointed, sir.
Yes, ma'am.
And they're going to need to look through that to be able to get that information in front of the judge that issued the warrant. I'm going by what the judge wrote, and they'll need that, just like you told me, the dates and the times, so that they can apply to that particular court, that division, to have that bond addressed, okay?
Is this another capias, or is it a warrant?
It's a capias, sorry.
Is it?
Yeah. It's a capias, per judge's order, zero bond. So he failed to appear.
Thank you, Judge.
That will remain the same.
Your Honor, Mr. Woods, Jonathan was a bond.
Bonded?
Bonded.
Bonded, okay.
So we have the plea.
Right, we got the plea. All right, we have your plea, and did we get that sorted through, everyone? Do we kind of know?
Yes, Your Honor. It appears the offer is a revoke and terminate Orange County Jail for 30 days with whatever credit, and then the cost of supervision. That's
Okay.
it.
So no, not reinstate probation
No.
or anything. That's perfect. As long as I know, I'm fine. It's just, there was just some
Yes.
question about what the offer was. So it's credit for serve, revoke and terminate, and take all the financial and give them a year to pay. Basically. Okay. All right, we're ready to go then.
Yes.
All right, your name, please.
Oh, Tyrone Hines.
All right.
Mhm.
At this time, Mr. Hines, sir, you're here. This was a violation of probation, and the case was set for an early plea, and thanks for being patient. We just, we needed to make sure what, the offers were and those agreements.
Okay.
And at this time, counsel, you may proceed.
Yes, Your Honor, this is in case 2020 MM 8564. An admission to a violation of probation. The terms of this admission will be admit to the technical, revoke and terminate probation, 30 days in the Orange County Jail, at $182.50 for the cost of supervision. I believe he's time served over the 30 days. I did have a chance to speak with Mr. Hines. Went over the form with him. He also had a chance to speak with his attorney, Assistant Public Defender Medina.
Okay.
And so I have signed the form as the attorney from the Office of the Public Defender. And does Mr. Hines have to sign the form?
Yes, you'll need to sign it, yeah. So he wishes to enter an admission. We'll put this on the order specifically to conditions 7 and 8. That is the technical violations, is that correct?
That's correct, Your Honor.
Conditions 7 and 8. No, he can admit to one of them, but he's 7 and 8.
And she's going to ask you for your signature.
All right. Mr. Hines, sir, is that your signature, sir, on the admission form?
Yes, Your Honor.
Did you understand all the rights that you're giving up by doing so?
Yes, ma'am.
And are you entering this admission on your own free will?
Yes, ma'am.
And both your attorneys have signed, once you're in the court, and you had Ms. Medina also that spoke to you separately also, and with the Public Defender's Office, correct?
Yes, ma'am.
All right. Are you under the influence of any alcohol, drugs, or medication that could affect your thinking?
No, ma'am.
All right. And are you on probation? You understand that by pleading today would subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, sir. And at this time, do you still wish to maintain your admitting to violating conditions 7 and 8?
Yes, ma'am.
I'll accept the admission. I find that you freely and voluntarily do so, and I will adjudicate you guilty, revoke and terminate your probation, sentence you to 32 days in the Orange County Jail with credit for 32 days' time served. You'll be released today. Cost of supervision will still need to pay. You'll need to pay that. It's $182.50.
Okay.
And the court costs, they're going to add them together, and I'll give you 1 year to take care of those.
Okay. Thank you, Your Honor.
You're welcome, sir. And do you have any other questions?
No, ma'am.
All right, you have the right to appeal the sentence of the court, must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you. Yes, sir.
Just one question. You know what time will I be being released today?
They're as anxious for you to leave as you are to leave, okay? All right. All right, thank you all. Was there anything else we needed to take care of?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, everybody, we'll stand in adjournment.